Thanks so much for having me along. I'm really excited to be here. I actually used to do a bit of debating and public speaking in this exact hall, so I'm getting some pretty vivid flashbacks, so bear with me if anything goes wrong. They say a good TED Talk spreads a new and interesting idea in a way that's relevant to its audience. And I just want to manage expectations early on here because, as you've just heard, I'm a lawyer. I spend a lot of time thinking about ideas relating to the law, and those ideas excite me. But I'm not sure how many of you will be that excited for me to spread them. And here I am at my old school, talking to a room full of high school teenage students. And if I think back to when I was in your seats about 15 years ago, give or take, I'm pretty sure one of the last things that I think would be relevant to me would be to hear from some older guy talking about the law. But I'm willing to give it a shot if all of you are. So in the next 15 minutes, I'm going to make a room full of teenage students excited, inspired, and hopefully genuinely care about the law. And I'm going to do that by talking to you guys about an old problem, a new challenge, and a borrowed solution. But before we do that, I just want to do a quick poll. In the room today, how many of you in the last few weeks have signed a contract? That's one. We can get some legal advice afterwards, but not many people in the room. So let's try something else. How many of you in the last few weeks have downloaded an app on your mobile phones? A lot more hands. What about browse the website like ATAR Notes or Board of Studies? Yeah, a lot of hands again. And who here is on an impressive streak on Snapchat? Anybody? Yeah, there's some streaks here. Okay, cool. If you've done any of those things, chances are you've also entered into a contract. In other words, you're pretty much entering into contracts all the time without really knowing you're doing it. Before we can go on, we need to have a lesson in contract law. Now I know I used the L word to a group full of students. You thought you were kind of getting the morning off class and I'm giving you a lesson. But I promise I'll make this as quick and painless as possible. Here we go. A contract is... these are some of the contracts you might have signed up to on those websites you've been visiting. So a contract is a legal agreement that happens when people or organisations want to make promises to each other. So for example, if I promise to give a talk at a school, and the principal promises to pay me lots of money, and we both see it as a serious arrangement, then in most cases, that's a contract. Legal disclaimer, I'm not actually getting paid for this. We'll make that very clear. As a side note, things would be a little bit different if instead of making that arrangement with the principal, I made it with one of the younger students, because children generally lack capacity, which is the law's way of saying you're not yet old enough to waste money on bad speakers. A contract is generally a physical document, which is written on paper and signed by pen, but you can also enter into a contract with your words and your conduct or your actions. But importantly, these days, lots and lots of contracts also exist in the digital world. So there you go, the lesson's over. There's no need to go to law school after all. I've just saved you 5 years of your life and lots of debt. No, I'm just kidding. I think going to university is a very smart choice, and thankfully a choice that's still financially viable for lots of people in our community today. So back to all those contracts that you're entering into without really knowing about. I'm assuming if you didn't even know you entered into them, you probably didn't take a chance to read them. And you probably didn't understand what they said. Unfortunately, this isn't actually a new thing. People have been blindly entering into contracts since well before the era of the internet or app stores. Law textbooks are scattered with cases about people being held to promises that are found on the back of parking tickets or dry cleaning coupons, even if they never actually read them or understood what was in them. So there we have our old problem. For a long time, people have been entering into contracts without really knowing what they're about. But these days, software is eating the world. And what that means is that technology is invading more and more aspects of our life. This here is the mantra of a Silicon Valley venture capital firm called Andreessen Horowitz. And as I said, what they're trying to convey here is that technology is increasingly becoming part of everything we do in life. But just as technology is invading lots of different parts of our lives, it's also enabling the silent but relentless spread of contracts. So these days, I actually think that contracts are eating the world. It might be hard for all of us to see, because they're not written on paper and they're not signed by pen. But these days, we're all being buried in digital reams of promises and obligations. To understand what's going on here, we need to take a look at two general rules of contract law. And I know, again, I'll make the lesson as quick and painless as possible. So the first rule, if you sign a contract, you agree to do what it says. It doesn't matter if you actually read it or understood what was in it, you're locked in. This rule kind of made sense when signing a contract looked a bit like this. But these days, signing a contract tends to look a bit more like this. This is what we call a click-wrap agreement. It's where you're asked to demonstrate that you agree to a contract by ticking a box or clicking a button before doing something online or in an app. Okay, that's the first general rule. Second general rule, you're also required to do what's in a contract if you are given what the law calls reasonable warning about it. Now, reasonable warning can look like lots of different things. One English judge in the 1970s famously said that reasonable warning, or it's also called notice, would need to be for a particularly nasty promise, printed in red ink with a big red hand, or something equally startling. But these days, reasonable warning or notice looks a bit more like this. So if any of you actually bothered to read the contracts, and again, I don't do this either, so I understand why no one's looked at it, you might have been a bit confused with why they suddenly jumped to all caps or bold. Chances are that's because they're trying to make you promise something particularly nasty. And they're trying to say, we gave you reasonable warning or notice of that. Which I personally find a bit strange because I think it's actually a lot harder to read it when it's in all caps, and it feels a bit like the web page is shouting at me. So there we have our new challenge. In the digital world, it's easier than ever to sign up to legal promises that you don't really understand. So we have our old problem, a new challenge, now we need to go out and borrow a solution. The French painter Henri Matisse was actually an aspiring lawyer before he took up the brush. Unfortunately, in this respect, Matisse runs a bit against the trend. In general, it's pretty rare for someone with a legal mind to also have an eye for design. Good lawyers, sadly, are not often good designers. But I think we need to borrow some key insights from design thinking to help us solve the problem of digital contracts. Depending on how cynical you are, design thinking is either one of the most wonderful, fantastic, best problem-solving frameworks ever developed, or just common sense. Either way, whichever side of the fence you're on, it's going to be pretty useful. The key principle, the guiding light of design thinking, is that you should always serve the real needs of users. This is really important to designers. They know that the thing they're designing has to actually do the thing it's being designed to do. So, you're all sitting on chairs. A good chair designer will know that at some point, someone's going to have to sit on the final product. If you can't sit on it, it's not a very good chair. I think this same logic needs to be applied to the law. If a contract doesn't serve the needs of its users, it's probably not a very good contract. But if we take a look at the contracts out there, some of which I've already shown to you, it seems like they're not doing a very good job at serving the needs of their users. They're long, they're boring, they're written in technical language, and obviously no one's actually reading them. So they can't really be serving the needs of users. But if, like me, you spend a lot of time in contracts, you begin to realize that the real problem is not that they're not serving the needs of their users, it's that they're serving the wrong needs. Any seasoned lawyer will tell you that the main purpose of a contract is to cover what happens when things go wrong. And in real life, IRL, lots of things tend to go wrong. These things might be really, really unlikely to happen, but a contract lawyer wants to shove them all into the contract just in case, which kind of explains why all these documents are really long, really boring, written in technical language, and none of us are actually reading them. But this view of contracts no longer works for the digital world in which we all live. We need to redefine the purpose of contracts to fit with our online existence. We need to redefine from contracts as conflict, contracts that cover all the things that go wrong when you need to have a fight, to contracts as collaboration. For me, contracts as collaboration means contracts that understand that businesses and individuals need to work together to design how they define their relationships. That all users of contracts need to have a shared understanding of the legal promises they're actually making. And that contracts are being used as roadmaps for working together, roadmaps for collaboration, rather than rule books for conflict. These ideals won't necessarily make sense for every contract. So if you have a complex agreement with lots of businesses to perform a specific thing at a specific time in certain circumstances, then you probably have to do it the old way, with the way that lawyers are used to doing it. But this approach is sorely needed, desperately needed, for all of those volume of contracts that all of us are signing up to as ordinary people every day without really knowing about it. And I think this matters most of all for all of the digital natives like you guys sitting here in the hall today. And it matters for three really important reasons. First of all, it matters because the digital promises we're making are real promises. In 2017, a court in the US said that when Uber puts hyperlinks below its registration button, then a reasonably prudent smartphone user, which is the law's way of saying everyone here today, a reasonably prudent smartphone user agrees to make the promises in those hyperlinks. The court even said that probably a lot of people won't bother to go and read those additional terms. But that didn't matter, according to the court, because that's the choice the user makes. So when you're making these digital promises, they are real and they are having legal force. Secondly, it matters to all of you because perhaps more than ever, these businesses that are asking you to sign these contracts depend on your contribution and your participation in what they're doing. Let me try and show you what I mean. Who here has brought along their phone? This is where you're able to pull out your phone. So I want you to open your phone and open Instagram. But that's probably the first time you've heard that at school for a long time from an adult, but you can open Instagram today. I want you to go to your home screen there and click on the little profile picture in the bottom right corner. Don't check all your notifications, we can do that later. I know you're very popular, but do that. Then at the top right corner you've got the three lines, the three horizontal lines. Click on that and go to the settings cog. Scroll down a bit, find about. Let me know if I'm going too quick. And then depending if you're an Apple user or an Android user, I'm on Pixel, so Android, click Terms of Use or Terms. You should then navigate to the Terms of Use. Scroll down a little bit until you find the section that says connecting you with brands, products and services in ways you care about. Should look a bit like this. For a start, pretty difficult to find, right? For those of you that stuck with me, well done. But second of all, have a quick read. If you look at what this says, it's basically saying that Instagram can use your information to sell you stuff. Or if you can find it, scroll a bit further down to the permissions you give us section. This section basically says that whenever you post something on Instagram, you're also giving Instagram a right to use that image. There's an old and overused expression in the tech world that says something along the lines of, if you're not paying for something, you're the product. Now that's not necessarily a bad thing, and as we've seen, it's the way a lot of businesses work in the modern economy. But you need to be aware of it. Because the point I'm trying to make is, without you, without all of us, there is no Facebook, there is no Instagram, there is no Snapchat. We are effectively all already digital collaborators with these businesses. So it seems only fair that we're given the opportunity to help define the rules of our collaboration. But finally, and I think most importantly, it matters to all of us because contracts are the cogs of our legal system and of our economy. Contracts are one of the most important tools for us to manage the way that individuals, people, businesses, organisations interact with each other in our society. We simply can't afford for contracts to become meaningless strings of words that you just click through so you can browse a website or play with an app that you've just downloaded or send a Snapchat to a friend. It's not an option. We really need to remember the importance of contracts. And so every time you click I accept for a contract you haven't read, you're also accepting a legal system where it's okay for ordinary people like us to make important legal promises that you don't actually understand. But you're also missing an opportunity to help us change this system and go for a new approach, an approach that better reflects the collaborative and digital world in which we live in. So here's my challenge to all of you. Next time you're coming across a digital contract because you're visiting a website or you're downloading an app, I know it'll be really tempting to just click the button or tick the box, but instead stop for a second and have a quick read. If there's something a bit strange or a bit wrong there, and usually as we've seen it will be the sections that are in bold or all caps, that should be a tip off. If there's something like that and you don't feel right about it, then don't just sign up. Instead, start a conversation about it. Send an email to the business and explain your concerns or ask for further information. Or maybe talk to a friend or post on one of the platforms you're already on. If enough of us do this, then businesses should listen because, as I've explained, they really do need us. So that's the promise that I'm asking all of you to make. And because you should understand this promise, I'm hoping you're willing to click I accept. Thank you.